So we start in alphabetical order, and that would be Belgrade that takes the floor first. So please, Belgrade.
Good morning. From our side once again. Yesterday we had a very fruitful discussion which lasted more than 2 hours. And now Ivana and me, we will summarize what we were speaking about. First, I will summarize the points that judges were endorsed because about the current constitutional reform, which is aimed to strengthen the independence of judiciary in Serbia, and the pending drafting of the constitutional amendments upon the government initiative was not in our focus. The judges present in the Rule of Law Forum here were focused on different issues and were mostly concerned about impartiality. The focus of yesterday's discussion was on the pressure of the judiciary expressed either in public comments on ongoing investigation, judicial proceedings or court decisions, or even on individual judges. We have learned from our judges that what worries were not only comments coming from governmental officials, but also from judges themselves in social media who are prone to comment the work on their colleagues. In addition, articles in tabloid newspapers targeting and seeking to discredit members of judiciary has been identified as yet another channel for putting the pressure on judiciary. So it seems that lack of impartiality actually worry judges, participants in the Rule of Law Forum. Here in Belgrade, we were also speaking about the need to reform the current system of recruitment, transfer and promotion of judges in order to ensure that their careers are fully based on merits. Currently, what is missing is a link between performance evaluation based on merits and promotion. Participation in continuous training should also be available, stressed our judges. They also emphasize the need to improve the transparency of their work and enhance the principles of legal certainty by advancing rules on harmonization of judicial practice. In this respect, it was said that the Supreme Court of Cassation role should be extended. Then I will also tell you what is going on now in Serbia, which we didn't discuss, and which was actually what I'm going to say is based on the Venice Commission characterization of the constitutional provisions regarding the judicial independence in Serbia. The Venice Commissions found that the independent bodies, the composition actually of independent bodies, was a recipe for politicization of judiciary because all of its 11 members are directly or indirectly elected by the national embassy. Currently in Serbia, the government had put the initiative in front of parliament for the constitutional reform that would eliminate this undue influence, and the working group has been established to draft the constitutional amendments, and the drafting is still pending. This should actually result in putting in place a fully objective, transparent and merit-based system of appointing, transferring and promoting members of the judiciary in line with European standards, including the jurisprudence of the European Court of Human Rights. And now I will pass floor to my colleague Ivana.
Good morning from my side as well. So I will focus on the issue of impartiality. And according to Serbian legislation, a judge is required to preserve confidence in their impartiality and to conduct proceedings impartially in accordance with their own assessment of facts and interpretation of law. The law prescribes reasons for recusal of a judge and a failure of a judge to request recusal in cases where there are reasons for recusal or exclusion foreseen by law is prescribed as disciplinary sanction. However, participants identified some cases when, in accordance with the jurisprudence of the European Court of Human Rights, violation of Article 6 possibly can be found. For example, when the same judicial council that delivered the judgment decides on extraordinary remedy, such as retrial request and further discussion with judges of the European Court of Human Rights is needed on this matter. A judge has the right and duty to advance professional education and training in Serbia. Initial and ongoing trainings are organized by the Judicial Academy, offering many courses, especially in the area of human rights and application of the European Convention on Human Rights. Many Help Council of Europe courses are offered, and some of them became a part of the compulsory initial training. Also, several anti-discrimination courses are organized, including workshops on breaking stereotypes and prejudices. Despite this, some participants underlined that a significant number of judges attend these courses, and this is only a small number of those, so it's not offered to all judges which should undergo these trainings. Also, some participants expressed their view that the training is still very much understood as training on law and not training on skills or non-judicial knowledge, and that the training needs to be more serious, comprehensive, and organized. Also, more trainings on ethics and integrity are needed in order to strengthen awareness, knowledge, and capacities of justice professionals. In addition to making decisions in court proceedings as representatives of the Judiciary, judges are also invited to participate in public discussions on laws that directly affect their work and the rights of citizens of the Republic of Serbia. At the same time, participants believe that judges should avoid criticism of their colleagues, especially on social media, as it can also undermine impartiality of the judiciary. As improper use of social media by judges can also endanger the impartiality of the judiciary, the practical guidelines has been developed with the Council of Europe support. Although the fight against corruption was among the government's priorities over the last decade, corruption remains the area of concern according to GRECO and European Commission. Reports on Serbia. Also, according to one USAID opinion poll from 2020, 44% of respondents have a perception that corruption exists in judiciary. At the same time, some normative and institutional mechanisms for the prevention of corruption in the judiciary have been established, which include the adoption and monitoring of integrity in plans and the adoption of the law on the protection of whistleblowers. Furthermore, progress has been made in establishing standards of professional ethics for judicial office holders, which are the basis for further strengthening the rule of law and citizens' trust in the judicial system. However, there is a need to improve the capacity of disciplinary bodies, as well as to establish a functional system for monitoring the implementation of codes of ethics and regulations. Special attention should be paid to improving the capacity and manner of action of ethics committees, which in accordance with international standards should provide an advisory role for holders of judicial office and deserve their trust. Despite the fact that the media communication strategy was adopted in 2018 by the High Judicial Council, the lack of communication and appearance of the judiciary representatives in media is still prevailing. This can be remedied by judicial institutions reaching out to the public and informing citizens of the key activities and procedures of the court by actively providing information to the public and making its work more transparent. This could also include bringing a selection of interesting cases to the public attention, organizing informal meetings with the national press, or promoting documentaries on the judiciary. The High Judicial Council needs to establish a PR service and to organize trainings on communication with media. So these are the conclusions from Serbian group. Thank you for your attention.
Thank you very much, Belgrade, for a really inspiring report. And then we move on to Podgorica now.
Good morning from Podgorica. Respected Mr. Brightwhite, Mr. Militic, and Mr. Usvatov, distinguished President, judges, and former judges of European Court, and dear colleagues. I wish to greet you all once again on behalf of Montenegro and express not only my pleasure, but the pleasure of all the participants of the forum who have been present at the National Hub of Montenegro, primarily with the very organization on the entire event, as well as very significant and interesting topics which were subject of discussion held yesterday. In front of my colleagues, I wish to show gratitude to our partners, the Art Center from London, Organization Civil Rights Defenders, and the Konrad Adenauer Foundation for organizing this forum with very important subject, that is independence and impartiality of judiciary. I'm going to start my presentation with the Plato's quote, who emphasized that the rule of law shall be the highest will in the state, and the rule of people shall be replaced by existing impartial and just laws. All the participants in discussion at our hub agreed with this quote, concluding that it is exclusively and standard of impartial and just laws that ensure independent and impartial judges. Like any other judiciary, the Montenegrin judiciary is not immune to the attempts to undermine its independence and the binding strength of the decision, both in internal or external level. As you have all been familiar with, Montenegro is going through the accession agreements towards the community to the European countries, and it is of vital importance to switch from moderately prepare for the implementation of the European standards in the area of the rule of law to fully fledged member for the application of all standards following the example of advanced West European democracy. All the participants in the discussion agree that in the practice Montenegro needs to strengthen the independence and the professionalism of the judiciary by a full and clear implementation of the relevant constitutional and legal provisions pursuant to the recommendation of the All-European body. We also reached a conclusion that it is necessary to establish the application of the Convention related standards within the national frameworks to a larger and clearer extent, since that is the only way which enables the interpretation and the application of law on a practical and effective manner, and not only theoretical or illusory one. We concluded that the common responsibility of all actors involved in the process is necessary for the purpose of securing the respect of human rights and fundamental freedoms at the national level, along with the existence of constructive dialogue among all parties capable of suggesting the solutions for the issues being identified. We acknowledge that in this moment, when Montenegro goes through the period of the redefining of the results achieved on its way towards the European Union, it is of utmost importance to enhance the independence of the judiciary, since it is the foundation of the principle, conditio sine qua non, establishing the rule of law as a cornerstone of democratic system and the rule of law of precondition for securing the protection of fundamental rights and freedoms at the national level. Now, I will pass floor to my colleague Snežana to continue. Thank you.
Thank you, Valentina. So in that direction, we agreed that the division of powers into legislative, executive, and judicial is aimed at preventing abuses of power which belongs to the state. The essence of power sharing is precisely their mutual relationship by which they limit each other. However, the reason why this forum has been so important to us lies in its role to observe such a right, not only from the aspect of the party, to be judged by an independent and impartial tribunal established by law, but also from the standpoint of a judge, making sure that he or she is equipped well to judge in an independent and impartial manner. Therefore, the handbook that was made by the Air Center and the human rights defenders on this topic, together with the review of relevant judgments and which has been distributed to the participants of the forum, is of essential importance to Montenegrin judges. Thus, it pays significant attention to the rights of judges. The provision and the implementation of this right is complementary to the right of the party. The action plan of the Council of Europe and its appendix indicate the following action needs to be taken. Firstly, establish and improve legal guarantees of judicial independence and impartiality. Secondly, put in place or introduce the necessary structures, policies, and practices to ensure that these guarantees are respected in practice and contribute to the proper functioning of the judicial branch in a democratic society based on human rights and the rule of law. The right to be independent and impartial is granted to all judges by the Constitution of Montenegro. Also, the law on judicial council and judges secures these rights. All state authorities, including the parliament and the executive, as well as judges, share the responsibility in promoting and protecting judicial independence. What has been identified in our national working group as a shortfall is the lack of the full capacity of securing the protection of these rights, although it is defined by the Constitution and the law. More precisely, apart from the announcement via media by the Judicial Council, which is entitled to secure this right to a judge pursuant to law, no other way of protection has been developed. In that context, we should consider establishing a special structure through a relevant body which would effectively and efficiently deal with the promotion and the securing of the protection of such a right. What has been particularly contested, brought into question, is the accountability of a judge towards the immunity and the deprivation of liberty of a judge. The attention should be paid to the adequate projection of the selection of the judges in the light of planning and filling vacancies, particularly the first instance courts. In that direction, the cooperation between the Judicial Council and the Judicial Training Center should be put in place in order to prevent the overcrowding and the failure to carry out the prescribed trainings in their full capacity. The current situation in Montenegro in respect to the state in judiciary, although not being formulated as a legal reform, is represented as such in essence. We have a situation that the Constitutional Court of Montenegro and the Supreme Court of Montenegro, as the highest instance courts in the country, are experiencing a significant lack of capacities and are currently incapable of responding to their task concerning the effectiveness. In that sense, we can find ourselves in a situation of re-examining the effectiveness of certain legal remedies before the European Court of Human Rights. Finally, the question of potential professionalization of members of the Judicial Council in the capacity of judges has been raised in order to perform as well as possible the function given to the jurisdiction of the Judicial Council, which is to ensure and protect the independence, responsibility and professionalism of courts and judges, which is of great importance for strengthening public confidence in courts and beyond, which is an indispensable condition for the rule of law.
Okay. Dear all, therefore, having in mind the present conclusions reached through the common discussion, encouraged by respected organizer and the participants of the forum, once again we wish to highlight the importance of the forum for Montenegrin judiciary. We are convinced that it will have a great contribution in the future for more effective application of the standards of the European Court of Human Rights and the strengthening of the independence and the impartiality of the Montenegrin judiciary. At the end, I wish to express my gratitude to the organizer, panelists, and all the participants on the holding another successful forum, which provide us with the valuable knowledge in the application of the relevant standards established by the European Court in decision. Thank you.
Thank Thank you very much, Podgorica. And now we move to the report of Pristina.
Good morning, everyone. Hope you are all well and rested, as yesterday was quite some day, and we had a fruitful discussion with the group here in Pristina as well. As per the topics, the two topics that we discussed with our participants, we all agreed that the independence and impartiality of the judiciary is perceived differently from inside the judiciary and differently from the broader public. However, the present judges elaborated that what remains of great importance is that in our system in Kosovo, there are constitutional and legal guarantees with regards to decision making and the immunity the judges have within their competences. At the same time, as a positive aspect, was mentioned the procedural and institutional guarantees that pertain to the process of appointment of judges and with regards to the Judicial Council as an independent body for administrating these procedures. That means that in Kosovo, the Judicial Council has all the legal competencies from the start. That means from initiating the call for vacancies up to the proposal it makes to the President of the Republic for the final and formal appointment of new judges. So the permanent mandate of judges was considered as well as a very strong guarantee. Meanwhile, a new regulation that has been lately practiced, is being practiced lately by the Council, is that there is no longer a necessity in requesting a decree from the President when it comes to the promotion of judges, which is also considered as another strong point in safeguarding and enhancing independence. Nonetheless, it came up also during the questions yesterday for the panel, but what was mentioned as an ongoing challenge in matters of upholding the independence of the judiciary is the issue of financing, and that has unfortunately not been addressed yet by any reform, but which is directly linked to the performance of the judiciary. The financial guarantees were considered by the participants as important in addressing the problem with the backlog of cases and the lengthy procedures, which is still a problem, but also for the engagement of new judges and for the necessary support staff, all of which participants thought that may lead to the infringement of Article 6 of the Convention. When it comes to Article 6, the Ombudsperson institution receives over 50% of the complaints from citizens on a yearly basis in relation to lengthy procedures of the courts. However, even though there has still not been a permanent solution to this systemic problem, the involvement of the Ombudsperson institution, at least it triggers a reply and interest from the courts in the specific cases most of the time. The participants also discussed and agreed on the need of the judiciary to communicate more with the public and portray its work and activities more extensively. As quite often, they said that the media reflects mainly the shortcomings of the judiciary, evading so the progress that is being achieved throughout the years. Hence, relying mostly on the information delivered by the media, and sometimes also on opinions of individuals that are not necessarily specialists and professionals of the judicial system, the general public is prone to perceiving the judiciary as not independent and impartial. As another factor of distrust that was also mentioned is the problem with decisions that are not so well elaborated or justified, also as a result of the quality of the decision-making process, as well as the culture of legal writing, all of which are areas that have room for improvement. I'll pass the floor to my colleague Flaka.
Thank you, Adona. Good morning to everyone. In addition to what my colleague Donna just briefed from our discussions yesterday, we dwelt a bit on the disbalance between Article 6 and Article 10 of the Convention. The participants stated that during the last couple of years, there has been a rise in cases where the media or the civil society initiated public discussions on specific cases before the case itself were resolved by the court. And to some extent, this was considered to be a kind of pressure exerted to the work of the judiciary. However, on the other hand, the fact that the judges have immunity, it is not often that for this kind of outside pressure to result in an actual effect. What was also considered intolerable is the pressure that can and may come from other state actors, which then is seen as a direct interference in the independence and impartiality of the judiciary. With regards to these two different forms of pressure exerted on the judiciary, the participants were of the belief that there is no need for frequent public reaction from the judiciary, as it should only come in specific cases in relation to addressing the issues only in principle and with the aim to assure the general public of the independence and impartiality of the judiciary. With regards to communications, it was also confirmed that there is personnel responsible for communicating with the public from all courts of Kosovo. However, there are no strategies or manuals, including here manuals on the usage of social media. But there is the code of conduct for the judges that aims to uphold the integrity of the judges in public and in private life. Participants from the judiciary considered that in terms of transparency, the judiciary in Kosovo has advanced quite a lot, as all the decisions are made public on their websites, as well as due to some internal regulations of the Judicial Council, all their meetings have started to be broadcasted online in real time, with the aim to achieve a higher level of trust among the citizens. These efforts have also been recognized by different international organizations as positive steps in increasing transparency. Finally, the participants in the Pristina hub stated that it is important that the judiciary builds close ties with the younger generations by conducting regular visits and aim to portray and build a better image of the judiciary among the youth, and as such bringing by a shift in the approach and mentality of our citizens with respect to the role and importance of an independent judicial system. Thank you all for your time and patience. That's all from Pristina.
Thank you very much for this report. And now we will move to Sarajevo.
Good morning, ladies and gentlemen. The group in Sarajevo has an active and useful discussion on the topic of our forum, and although each question would request, if not a separate forum, then at least several hours of discussion, we tried to, and hopefully succeeded, to discuss all of these very important issues. These are the main observations of the group concerning the independence and impartiality of judiciary in BiH. As regards the independence of judiciary, it is clear that there are no constitutional guarantees of independence of judiciary prescribed by the Constitution of Bosnia and Herzegovina. However, given the direct application of the European Convention and its priority over all other laws, as guaranteed in the BiH Constitution, judicial independence is guaranteed by the direct application of the ECHR and its Article 6. It was also noted that entity constitutions guarantee the independence of judiciary as well as the BiH law on High Judicial and Prosecutorial Council. Therefore, it appears that insisting on amendments to the BiH constitution in order to ensure judicial independence is not dealing with the crux of the matter. Amendments to the BiH constitution in this sense is politically difficult, if not even impossible task in the current political circumstances, and it should not be at the top of recommendations that seek to strengthen the independence of judiciary. On the other side, the future constitutional reform should include harmonization of the constitution with the factual and legislative situation in Bosnia. For instance, although there is an impression that there might be conflict between the normative and the actual situation, it is pointed out that there are no obstacles to the work of High Judicial and Prosecutorial Council. However, it would be ideal for the Constitution to prescribe the High Judicial and Prosecutorial Council as an independent body that elect judges and prosecutors. Again, this is highly dependent on the political will and not quite feasible in the near future. Further, the group discussed whether there are adequate legal guarantees for the independence of the judiciary, and it was noted that the procedure of appointing judges has become stricter in the last 8 months since the time that structural changes in the High Judicial and Prosecutorial Council occurred, and that there is a legal basis for selecting the best candidates for the position of the holders of judicial functions. But it was also concluded that there is still need to further improve the appointment proceeding that must be objective and transparent and based on merits, ethics, and integrity. Also, there is a strong need to address the process of testing candidates for judicial positions and to secure the right to appeal the decisions on the appointment of judges and prosecutors. In terms of promotion of judges, there were much more objections because the system is not adequate. The system of promotion of judges does not show the differences between judges in the quality of their work, and if the quality assessment remains as it is, based more on statistics than on the real quality of work, the impression of the independence and efficiency of judiciary will remain very low according to several reports of international and national bodies and organizations. As to the key issues for further judicial reform, it was really difficult to choose just one, but in the end, it was concluded that the crucial issue is the adoption of the new law on High Judicial and Prosecutorial Council, the draft of which is still pending in the BiH Parliamentary Assembly, some 5 years now, and it is also necessary to secure independent and full financial independence of the judiciary. The group also concluded that in order to improve efficiency of the courts, the High Judicial and Prosecutorial Council, in association with judges' associations, should analyze the current organization and jurisdiction of courts and make recommendations for improvements. For instance, thousands of utility cases have been dealt with by the same courts that decide in civil and criminal proceedings. In particular, utility cases should be out of court jurisdiction, as it has been recommended years ago by the Venice Commission and other bodies and organizations. The result of the current organization is reflected also in the fact that the Constitutional Court currently has thousands of cases pending cases related to the right of a trial within a reasonable time. It was also stressed that although the High Judicial and Prosecutorial Council cannot make all these changes itself, it can certainly be a driving force behind them. Participants also stressed out the importance of further improvement of education and professional training of judges and prosecutors. ongoing as well as for those who are entering the judiciary for the first time. The group also supported the main findings from the recent OSCE report in relation to the Institute of Additional Judges, which does not correspond to its original purpose of reducing the number on unresolved so-called old cases, and is not in accordance with laws and regulations, and this issue should be dealt with efficiently. As to the role of professional associations, it was stressed that associations are very important as a tool of a democratization of judiciary, and although the Federation Association of Judges has had activities in various phases of judicial reform in recent years, it has not been seen as a partner whose proposals and initiatives would be taken into account by High Judicial and Prosecutorial Council. Thus, although the position of associations may be weak at this time, with support from the High Judicial and Prosecutorial Council and more enthusiasm from judges to actively be involved in the work of association, there is a room and need for their stronger influence on the ongoing reform processes. As regards the question on what is driving the reform, it was mentioned that the BIH has signed a stabilization and association agreement, and therefore is obliged to fulfill conditions from Chapter 23, and at the same time ECHR, that is enshrined in the BIH Constitution and the court's case law that is consistently applied by the BIH Constitutional Court, serve as a pressure and guidance for further reform. And I would now like to turn to Elma. Thank you.
Thank you. I will now go on with our observations and conclusions from yesterday. And although short in time, yesterday in the afternoon, the group noted some positive reform results so far. For example, it was stated that reform efforts in 2003, which is considered to be the year to be a starting point for judicial reform in Bosnia and Herzegovina, significantly improved the overall judicial system, including the creation of the independent body of the High Judicial and Prosecutorial Council as independent body whose main task is to secure independence of judiciary. Also, it was noticed that standards from the European Convention have been incorporated into several procedural laws, and the major steps forward have been made to that end, supporting the independence of the judiciary as well. Further, increasingly, it was noted that regular courts refer to the decisions of the Constitutional Court, the case law of the European Court of Human Rights too, or directly comment or apply the European Convention, which is the result of training as well. As regards the level of corruption issues within the judiciary, the group reminded that in Bosnia, it is rated as highly corrupt in this area. However, participants concluded that the negative perception of judges as corrupt is high also because of poor quality of decisions that support such perception together with lack of integrity of judges. However, everything related to other procedures, from appointments, recruitment and promotions of judges to their removal, should be assessed in the context of corruption, as was also suggested in the recent report by the Open Society Fund, Bosnia and Herzegovina, on so-called captured judiciary. As regards the question of impartiality, the group concluded that it can be seen that there are indeed legally defined guarantees that safeguard it. In addition, the conclusion is that no serious problems regarding this principle have been determined, and the number of cases that the Constitutional Court dealt with was resolved by applying the European Court on Human Rights standards. It was discussed whether judges are exposed to pressure through media reports, and especially through hostile reporting on the accused, and how to protect judges from such pressures. It has been observed that the media often report on judges in a biased manner, and that the media often conduct trials in the media themselves, instead of leaving it in the courtroom, often not understanding the basic principles of the procedures or contents. On the other hand, media play a big role, and judges feel that they are being pressured in this way. Thus, the continuous education of judges, training of judges regarding communication ways with the media is of importance as well.
Related to communication strategy to the media, the participants reminded that there are regulations, for example, rule books, that prescribe the manner of communication with the media. However, these rule books are either partially implemented or unevenly. The representative of the High Judicial and Prosecutorial Council pointed out that this body is currently working on a communication strategy that will regulate this issue in detail in order to solve the problems in this area. This will also cover the guidelines on judges' use of social media. As regards the disciplinary proceedings against judges, it was concluded that the disciplinary offenses need to be reviewed and clarified with a view to reducing the scope for arbitrary application of the relevant provisions in specific cases, as well as separating disciplinary offenses from negative performance evaluations. In the end, although certain good practices were observed, it was found that there is a certain delay in the development of the judiciary, which is partly caused by the lack of political will, but also insufficient engagement in analyzing the current situation, amending laws, and adopting new laws. Also, intensive work on personal integrity is mentioned as a significant segment without which neither quality nor public trust can be achieved. These were the main findings from Sarajevo Hub. Thank you very much.
Thank you for, as ever, detailed and inspiring report from Sarajevo. And now we move to Skopje, please.
Good morning from Skopje as well. We had a fruitful and very interesting discussion after the very inspiring presentations from yesterday, and I will present the main findings and main observations concerning the independence and judicial independence in North Macedonia, while my colleague Velimir will discuss the aspects on impartiality. It is very interesting to observe that, and closely following the previous speakers, that most of the issues are rather shared also throughout the region, but also in North Macedonia. So it is interesting as well to know that in the past 30 years, since North Macedonia gained its independence, one term has been most frequently associated with the judiciary and has overshadowed other notions usually related to it. This term is neither independence nor impartiality, but rather reform. The judiciary has been in constant process of reforms. However, we have been missing substantial results and sustainable change for the better. Even though certain progress could be noticed, still the expected results have not been put in place. This could be easily observed also through the level of trust in the judiciary and accordingly injustice being done and served. Namely, according to the latest national survey of the public opinion in North Macedonia conducted by the International Republican Institute in March and April 2021, the level of trust in the judiciary is only 3%, rather staggering, and somewhat trust is 21%. These percentages are only slightly higher when compared to the actual experience and the survey on the actual experience with the judiciary of the parties that had certain court cases within the judiciary, and it is only up to almost 40% trust in the judiciary, which is also relatively low. This relatively negative image is perceived to be the result of the skeptical view on judicial independence and impartiality, the perception of high level of corruption within the judiciary, the negative media reporting, something that was mentioned before as well, and also occasional negative public statements by certain officials, as well as attorneys at law. And also the judicial reasonings are also one of the issues that have been raised to influence this negative image of the judiciary. It should be noted that North Macedonia has been the first country in the region to initiate EU-induced judicial reforms already in 2005 through the introduction and enactment of a large package of constitutional amendments related to the judiciary and the public prosecutor's office. However, here and within this constitutional amendments, the amendments on the constitutional court have not been adopted. And since then, there were several tries and attempts to introduce constitutional amendments concerning constitutional adjudication in constitutional court. However, these attempts have not been successful. In this sense, it could be observed when it comes to the judiciary that the constitutional legal framework has been rather aligned with the European standards, and it has been continuously improved throughout the years, also taking into consideration the case law concerning North Macedonia before the European Court on Human Rights, especially concerning the issues related to the dismissal of judges. Also, these European standards have been met through the establishment since 2005 and 2006 of a strong judicial council, which has a rather high concentration of constitutional powers related to the governance within the judiciary. So we have a high level formally of judicial self-governance. And also we have introduced a new training body that is the Academy on Judges and Prosecutors. Throughout these years, the Academy on Judges and Prosecutors, especially in the past 2 years, has improved its image and strengthened its capacity, and it's continually doing so. However, the Judicial Council is still being perceived rather skeptically in the sense that it still is perceived to be captured by the interest of the political elites. So in certain aspects, the Judicial Council is perceived more as safeguarding the interests of the political elites within the judiciary, particularly of the executive power and the political party elites, and not so much of safeguarding and guaranteeing judicial independence. These negative influences on the judicial independence, which are an obstacle for creating a sustainable and lasting culture of judicial independence within the judiciary, have been perceived to be mainly exerted through the judicial careers and the financial independence. In this sense, it was observed yesterday that the level of influence of the executive is to be seen, and this negative influence is to be seen particularly through the processes of promotion, dismissal, and disciplinary proceedings against judges. In this sense, there were several instances in which, especially the promotion of judges and judicial promotions, had been contested and challenged in public. However, what could be noticed as well is that in all these cases, it was the level of, or the number of appeals against these judicial promotions of the judicial councils had been relatively low. So even the judges themselves, it could be said that do not trust the system and the process, and they're frequently not appealing these decisions, even in cases where they have publicly challenged these judicial promotions or elections. When it comes to the financial independence, it was emphasized that the material resources and conditions are relatively poor in the country, especially in the context of the statutory obligation of 0.8% of the GDP is supposed to be allocated to the judiciary. However, we have not reached this level of financing, and the current level is on 0.4 from the GDP. The salaries are among the lowest in the region, and we are continuously lacking in judicial staff and clerks. However, on the other side, it was also mentioned that there are certain and often cases of poor financial management by certain courts. So certain funds and funding are not being properly used. When it comes to corruption, discussion went in the direction that corruption is present in individual cases, and it's not a matter of a systemic problem. Ironically, the predominant perception within the judicial ranks is not matched by a high number of corruption cases against judges. On the contrary, there are very few cases of corruption against judges, which opens another dilemma, whether other institutions are not performing well, or the perception of corruption is not the most accurate one. Lastly, it was observed that even though we have entered and opened several legislative cycles and reform cycles, including legislative changes and amendments in our legal framework in a continuous alignment with European standards, it was noted that certain issues could not be tackled through legislative changes, and that certain problems related to judicial independence will remain unresolved, even if such legislative changes are introduced. It was revealed that the judicial culture and mentality play a significant role. So in this sense, even though formal rules and institutions have been put in place and have been introduced in the country, especially since 2005, there are certain informal practices that play an equally significant role in achieving sustainable judicial independence. It was observed that the main path for addressing these issues, especially the issues of ethics and integrity, and as well as entrenchment of genuine and autochthonous culture on judicial independence, thus building a tradition on judicial independence, are mainly through legal education and judicial training. It could be noticed, sadly, especially from my side, that legal education has not been reformed and plays not that important role in building this culture on judicial independence. The outmoded and not really updated methods of legal education negatively influence also the process of establishing this judicial independence and improving the quality, especially of justice. In certain cases, the judicial training, which comes later, could not fill in these gaps. Thus, there is an obvious need of reform of our formal legal education, and certain educational legacies could be observed to be also from the previous systems, such as formalism and textualism, as well as not using really case law in the process of formal legal education. We also mentioned, lastly, the burning issue, I would say, of the constitutional adjudication and the status and negative authority and image of the Constitutional Court. And we touched upon the latest issue concerning the election of constitutional justices. And we pointed out one specific situation that we are faced with in North Macedonia, and that's concerning the legal framework on the Constitutional Court and constitutional review in the country. I'm not sure if the public is aware, and if in the other countries our colleagues are aware, but we are perhaps the only country, with the slight exception of Bosnia and Herzegovina, that do not have any statutory regulation, so we don't have any statutory statute on the Constitutional Court. So neither the procedure nor the procedure before the court, the constitutional powers partly, and the procedure and conditions and requirements for election of constitutional justices have been regulated within a separate statute. Actually, they have not been regulated by a statute at all. The only constitutional bases are rather vague and broad, which leaves ample room for interpretation by political parties, since the only condition for the appointment and election of constitutional justices is for a person to be from the ranks of distinguished lawyers, which does not really mean a lot in this country, especially in light of certain elections of the constitutional judges in the country. So on this note, I would like to finish on the part of in the judicial independence in North Macedonia and pass the floor to my colleague, Belgrade. Come here, please.
Thank you. As Denis already said, I will focus more on the conclusions and findings from our discussion on impartiality.
So, sorry
all
if I may
participants
just
agree that the current national legal framework, there are sufficient guarantees and safeguards to exclude any legitimate doubts in courts' impartiality, in judges' impartiality. But on the other hand, according to the officially accessible statistical data, there is a high number of instances where judges are excluded from cases for various reasons. And this may raise concerns as to whether the mechanisms for exclusion are abused in order to avoid sitting on particular cases which are considered to be highly sensitive or to attract greater media attention. On the contrary, there is also a lack of knowledge of the judges on the ECHR standards regarding functional impartiality, and they are not always able to assess whether they are performing different functions relating to the same case would raise certain issues under the convention. Yesterday, President Spano emphasized the importance of diversity of judicial benches. This is furthermore important in the multicultural societies in the Balkans. But moreover, judges should ensure that all individuals, irrespective of their backgrounds, are treated equally before the law. During our discussion, we all agreed that the Judicial Academy, the Academy on Judges and Prosecutors, should continue playing its crucial role in this regard, in providing adequate, necessary training to judges, especially to candidate judges which are enrolled in the initial training program, including on issues on non-discrimination and breaking stereotypes and prejudice, so that future judges would be capable to recognize situations in which individuals may feel that judges were biased. This is also in line with opinion number 7 on Justice and Society of the Consultative Council of European Judges, as a recommendation with a view to enhancing public confidence in the courts. And one of the steps in this respect could also be the Help Online course on anti-discrimination, for example, which the Academy is planning to launch by the end of this year. There are several factors which contribute to a negative perception of the judiciary among the public, and of course, it is the image, and such negative image is influenced by media, but also is shaped to a certain extent by the impressions gained by citizens who participate as parties in court proceedings, due to the excessive duration of trials or personal dissatisfaction with the outcomes of their cases brought before courts. It was also noted during our discussion that Macedonian judges are subject to pressure which is resulting from negative adverse media coverage and from the frequent violations of presumption of innocence and right to privacy, not only by media but also by defense lawyers, politicians, other public figures, which undermine the guarantees of Articles 6 and 8 of the Convention. It should therefore be expected that the Judicial Council should deliver its mandate as guardian of independence and impartiality, also by shielding judges from such pressure. But also there is a certain room for action by court presidents in this respect, in line with opinion number 19. As regards transparency, there is a perception that in the public, that the work of judiciary is not sufficiently transparent, and that there is a room for improvement in this respect. Although the courts tend to be more open to the public, they lack specific communication strategies with the media, and most of them do not have their own communications and public relations teams. It was therefore suggested that they should prepare and publish press releases on all relevant ongoing court proceedings in order to prevent disinformation, which is often spread by defense lawyers or other persons who take the advantage of absence of official and timely information by the courts. Also, the courts should adopt a more proactive approach when it comes to publication of their decisions, which are not always accessible to the public in a user-friendly database. One of the positive steps forward, which was taken with aiming to improve the dialogue between judges and journalists. Okay. Should we stop here?
Sorry, can you hear me now in Skopje?
Yes.
No, can you hear me in Skopje now?
Yeah, we can hear you, Krasimir.
Okay, so could you please really sum up? You have 2 minutes left. You are already severely running out of your time and taking time for other 2 hubs that we have. So please sum up in 1 or 2 minutes remaining.
Okay, I will try. one of the positive steps which was taken and which aims at launching dialogue between judges and journalists was the establishment of the Judiciary Media Council, which was set up by the Association of Judges, following a US model, includes representatives of both professions, and should provide better access for the media to court to information, but also should ensure dissemination of to the public of objective information on court proceedings. Actually, setting up of such effective and independent mechanism was also recommended by the Consultative Council in its opinion number 7. It was welcomed and its contribution to the strengthening the judicial transparency was welcomed by the EU Commission in its progress report. And this is one of the good practices which we could share with other countries from the region. I will come to the, I will try to sum up and just to mention that we have also addressed the issue of striking a fair balance between Article 6 and Article 10 when it comes to freedom of expression of judges in social media. And the participants concluded in this respect that even though certain guidelines on the use of social media by judges are already provided by the Code of Judicial Ethics, the Judicial Council should also be more active in this respect. And in any event, judges should refrain from excessive exposure of their private and family life in social media and should exercise this freedom of expression in a dignified manner which does not undermine the authority and impartiality of judiciary. To sum up at the end, as Judge Lemons yesterday pointed out, public confidence in the judiciary should primarily be earned by judges. This is also relevant for the Macedonian context. And in addition to this, all other relevant stakeholders should bear their responsibility and contribute actively to safeguarding and fostering this culture of independence and impartiality of judges, so that the public confidence in judiciary is restored, but also to prevent the occurrence of future violations of Article 6 before the court. Thank you very much for your attention, and apologies for taking more time.
Okay, thank you very much, Skopje, and we now immediately turn to Tirana, and I would really kindly request you to keep your 10 minutes allocated time. Thank you. We are unable to hear Tirana. There is some technical problem. Could you what I would propose, there seems to be a technical problem and we are running a little bit out of time. So what I would propose is that we go immediately to Zagreb, and then until the technical issues are settled in Tirana, we will then come back to you. So Zagreb, please.
Thank you. Thank you for the floor. So the organizers, Mr. Kamber, participants, dear colleagues, at the outset, I would like to welcome the organizers' initiative and effort to gather us all once again here at the 8th Annual Regional Rule of Law Forum. Although the organizers are indeed successful in managing the forum in this format for the second year around, we still hope to see each other in person in the near future. During the discussion in Zagreb Hub, it was emphasized that impartiality and independence of the judges and courts are the core stones of the rule of law. As such, they are essential conventional rights crucial for functioning of domestic legal systems in democratic societies. First and foremost, it is of fundamental importance in a democratic society that the courts inspire confidence within the public. The independence of judiciary is closely linked to the way the judiciary's work is perceived by general public. It is also closely connected to the authority of the judiciary and the confidence in judiciary from inside and outside. Independent judiciary can also guarantee some of the other principles guaranteed by the Convention, which represent which represents the fundamental elements of the rule of law, such as legality, legal certainty, preventing abuse of power, equality before law, and access to justice. Judges are the means by which prevailing interests of other powers, executive and legislative, are restrained. Independent and impartial judges guarantee that all individuals, irrespective of their backgrounds, are treated equally before the law, without any prejudice or discrimination, and in respect with the requirements of the Convention. Therefore, during the yesterday discussion, once again, it was emphasized how important is vocational training for judges in the societies based on separation of powers. In this respect, the representatives of the Judicial Academy informed us of subjects regularly taught during initial training addressing ethics and deontology. Also, the Judicial Academy in Croatia provides trainings for sitting judges, especially those who also perform the function of spokespersons on topics such as how to better communicate with general and professional public. Currently, the Academy is also involved in a project with judges drafting a communication strategy for them. It is an interesting news that the Supreme Court opened its Twitter account as an additional tool for communication with public. In its accession to the European Union, Croatia has fulfilled all requirements regarding the protection of human rights and the rule of law set forth before her and has adopted the entire EU acquis. But more is to be done, which is indicated through the cases still coming before the court against Croatia and pending before it. The court has delivered a number of judgments in respect of Croatia which concern independence and impartiality of the judges and courts, or the right to a fair tribunal by an independent and impartial tribunal established by law. On a number of occasions, the court has stated that it is not only the judges should be objective or impartial, but they also at all times leave the impression of impartialities. Judges should therefore maintain and enforce high standards of conduct and should personally observe those standards so as to maintain the integrity of the judiciary. Any breach of such standards diminishes public confidence, which the courts in a democratic society must inspire in public. Further, strong and independent judiciary performs yet another important role, and it is within the conventional system, that is the protection of the principle of subsidiarity. It secures, as the president of the court, Judge Spano, yesterday rightly pointed, the application of the convention on national level in its first instance court proceedings. Since entering into force of the Protocol 15, this role has been even more strengthened. To conclude, the rule of law cannot properly function without the independent judiciary. They are also closely linked, that one cannot exist without the other. So we thank you again for this opportunity to talk among each other until we will be able to meet in person, and we send you our warm regards from Zagreb. Thank you very much for the floor.
Thank you very much, Zagreb. Thank you, Štefica. We now move to Tirana if we manage to resolve the technical problem.
Okay, thank you. Now we resolve the problem, I think, and good. All the participants on the topics on the impartiality and the independence of the judiciary. Me and my colleague Petrina are going to make a summary in a nutshell on the discussion according to the topics. We agree, all the participants in this hub, that the justice reform has improved the independence and impartiality of the magistrates. And concerning the independence, we can say that the constitutional guarantee on the independence of the judiciary are considered appropriate. Appointments of the judges and prosecutors are managed by the new self-governing institution of the judiciary, subject to completion of the compulsory initial training of the magistrate school, which has been a significant guarantee for the magistrate independence. The High Council of Justice check the candidates' merits and assets prior to their admission. The reform has in addition strengthened and guaranteed the independence as regards career, advancements and promotion, which are managed by the new justice institution with reinforced independence safeguards in place. Judges cannot be transferred without their consent except in the event of the disciplinary measures justified by the changes or temporary need. Appeal procedures are available against disciplinary measures concerning the magistrate. Judges can be dismissed only for serious misconduct or if being sentenced for criminal offense. They can also lodge appeals against the dismissal decision on the Constitutional Court. Attempted interference with the judiciary, including by the authorities within the judiciary, internal and outside pressure remain an issue here in Albania. Laws provide for administrative and criminal sanction in cases of undue influence over a court case or when magistrates consider their independence to be jeopardized, falling under the jurisdiction of the Special Prosecutor Office. The Constitution guarantees an independent budget for the judiciary, which is proposed and administered by the High Council of Justice, while the independence of the judges is guaranteed by the provision that as a rule of salary and other benefits of judges cannot be reduced, while 3 exceptional cases are envisaged. One of these cases is where a disciplinary measure is imposed on the judge in accordance with the law on the status of judges and prosecutors in the Republic of Albania. On the disciplinary sanction is the temporary reduction of the salary of the judge. However, the budget of the courts should follow the Council of Europe guidelines. It is allocated from the government, but it is made from the court, and this should be adjusted for inflation. The national strategy of 2021 to 2025 should prioritize investment in IT infrastructure, case management software and the like for the safeguard of the independence of the judiciary. In the case of the Constitutional Court, diversity in the composition of the court regarding professional background, judiciary, academia, gender, etc. is important to be achieved. Currently, there are only 2 judges with a background from the judiciary. The efficiency of the court remains problematic. There are delays and case backlog as a result of the vetting process. This is caused both from the reduced number of judges. Temporary transfer to different courts are seen as a tool to help mitigate the situation, but still it is very problematic. The judges that are temporarily transferred do not receive any extra remuneration to cover additional costs. A proposed solution to help with the backlog is the use of contracted staff to work on the cases from outside of the judiciary system. For all the participants here, it has been agreed that although this might be problematic, an increase of the number of the advisor on the court of the first instance and appeals should be considered instead. Considering the reform, we may say that in the case of Albania, the reform is driven by a multitude of factors. Internal pressure caused from the perceived of the high level of the corruption, a lack of independence and impartiality, and political intervention in the judiciary made necessary a deep reform on the justice system. But also the process of EU integration and standard of the Council of Europe are important drivers of the reform. The main international partners in the justice reform include the EU, US Embassy, other embassy, and development partners here in Albania. Legal reform has many aspects, not only the vetting, but there are many discussion, pros and cons, where the reform started, from the first instance or not. Legal framework on the judicial reform has been found complicated in interpretation, producing some problems with interpretation and establishment or reestablishment of the justice institution, including Supreme Court and Constitutional Court. However, the institution of the justice reforms are functional now, and the vetting process has outside part of judges that did not deserve to be part of the judiciary. However, it is a short time to assess the result of the reform, although so far its effect has been adverse when considering backlogs and delays from the reduced number of judges in the courts. And especially the effect of the reform has been the paralyzing of the work of the Constitutional Court and the Supreme Court. However, in medium and long term, it is foreseen that the reform will be positive. It has been noticed that there is a decrease in the number of the complaints towards the judiciary, both in public opinion and in the Ombudsman Office. One of the factors could be the diminishing of the negative narrative toward judges and the positive narrative around the reform. Professional Association of Judges have voiced publicly their concern and addressed the Constitutional Court about the problems concerning the independence. There are certain guarantees to ensure that judges are free from undue influence, both from within and outside. However, this is highly subjective issue and will be depend on the individual judge. The High Council of Judges are responsible for approving and monitoring the ethical rules of the conduct. Also, the High Council of Justice has improved evaluation forms and adapted them from the new legal standard. However, regular evaluation of judges' performance remains to be implemented. The Code of Ethics for the judges and prosecutors is now regulated by law. Despite the overall strengthening and independence of across the sector through the comprehensive justice reform, the Minister of Justice still retains the right to submit complaints, asking the High Council, the High Justice Inspectorate to investigate on the magistrate. This prerogative of the Minister has continued to be used during this period. According to the survey on the corruption, there is a barometer about on 2020 about the perception of the corruption in Albania. Trust in the courts also remain low, with 45% of citizens saying they have no trust at all, the highest absolute percentage of all the institutions surveyed. There is, however, a low percentage point decline in this figure compared to 2019, a positive change. Yet the percentage of those who say that they have a lot of trust in the courts has decreased as well, albeit by a insignificant amount from 6.2% to 5%. Overall, corruption is prevalent in many areas and remains an issue of concern. As far as the reform has not finished, the corruption remains systemic and not individual. Operational reforms against corruption are bringing results. Judicial follow-up must be ensured to increase the number of final conviction in high-level cases. And thank you we try to give in a nutshell some conclusion on the independence of the court, of the judiciary, and my colleague Petrina we make some sum up on the impartiality of the judiciary.
Thank you. The key points discussed in Albanian National Working Group regarding impartiality of the judiciary are: there are sufficient guarantees and safeguards to exclude any legitimate doubts in relation to a judge's impartiality, whilst judgment should therefore be reasoned and pronounced publicly. Judges should not otherwise be obliged to justify the reasons for their judgments outside of the judicial proceeding. To satisfy the requirements of objective impartiality, there are sufficient guarantees and safeguards in place to exclude any legitimate doubts in relation to a judge's impartiality. There are rules in place regulating the withdrawal of judges or their exclusion from parties that ensure impartiality. However, there is a problematic perception in the division of the cases in the courts of the first instance and appeal courts, which should be monitored. There are appropriate qualifications for judges in terms of their appointment and promotion based on meritocracy and transparency. Constitutional and legal changes have reduced political influence during the appointment process, ensuring a merit-based career system exclusively managed by the self-governing institutions of the judiciary. The Justice Appointment Council adopted 2 detailed regulations for the evaluation and the ranking of the candidates for the Constitutional Court and the High Justice Inspectorate. The School of Magistrates is in charge for the training of magistrates and is considered that it provides a good training program and in line with judges' requests. It offers trainings on non-discrimination and breaking stereotypes and prejudices. However, there is a need for access to research database and to update. Yes?
Tirana, can you hear me? Could I kindly ask you to sum up in 1 minute?
Okay. I will try. However, there is a need to access to research databases and update the library with more recent publication, which includes more case law analysis. Extended case duration, lack of adequate reasoning, and different decisions made in similar cases are factors that contribute to a negative perception of the judiciary among public. The right to appeal goes some way to rectifying this negative perception, as well as there are cases of abuse from the state bodies which appeal cases which shouldn't. The legal definition for the list of misconducts for judges and prosecutors as a basis for disciplinary proceedings have been now regulated by law. High Judicial Council is responsible for imposing disciplinary sanctions against judges. In general, these sanctions are considered appropriate, except the temporary reduction of the salary. There are no guidelines on judges' use of social media, but anyway, it is mentioned in the Code of Ethics, but there is no specific. Thank you.
Okay, thank you very much, Tirana, and thank you very much to all national hubs. We are a little bit running out of time, so I will try in literally a minute or two to point to some of the topics that are really cutting across all the reports that we've heard. We have seen that there are many legal reforms that are being implemented or have already been implemented in different legal systems, but the problem that appears to be is the application of this legal framework. What is important is that the legal framework seems to be very much influenced, and in some countries, such as Bosnia and Herzegovina, even directly influenced by the convention and the way how the court interprets that convention. So I think that all the developments in the case law of the court could also advise the authorities in the application of that framework that seems to be either put in place or is on a good track to be put in place. The problem that was also very much mentioned across the reports is the independence and impartiality of judiciary from within and from the perspective of the general public, and also from executive branches of the government. There is in this relation something which one wouldn't hear if one participated in a conference of this kind 10 years ago, when there was this mantra which said that courts communicate with the public through its judgments. These days we hear that in all legal systems there is a big need to ensure proper communication between the courts and the public. And some good trends are being heard, such as, for instance, opening of Twitter accounts by the superior courts and similar actions. Linked to this again, something which is frequently mentioned is the problem of corruption perception, in particular in some of the country reports that we heard. Scientific evidence shows that there is no necessarily correlation between the corruption perception and the actual corruption in a country, but this is something that the judiciary needs to tackle, and this was emphasized by several participants. And finally, something which is also critical is the question of education, in particular education through judicial academies, and we have seen that many different actions are taken in that field. So this sums up the national reports. I once again thank all the participants and all the national hubs for their participation. Thank you very much.